Okay. Well, let's see. I'll call to order the Property Maintenance Review Board meeting of July the 12th, 2023 at 7 o'clock. Clerk, will you please call the roll?
Member Vander?
Here.
Member Davis?
Here.
Member Pierpont?
Here.
Member Coy?
Here.
And Member Sarbat is absent, 4 present.
Thank you. Is there a motion and a second to approve the minutes from the January 11th, 2023 as presented?
I'll make a motion. Second.
All in favor?
Aye.
Any opposed? All right, the motion carries. Now tonight we have in front of us appeal number PMRB 23-10, the 800 Everhard Road Southwest. Appeal of the notice of administrative warning filed by Jeff Linker of Granite Property Management Company. First case this evening. Before we begin, a few procedural notes. Before anyone begins speaking this evening, please start by identifying yourself to our stenographer for the record, and any non-attorney speaker will be sworn in before speaking. Our clerk will keep a running list of which document is which exhibit letter as the parties present this evening. In addition, any document that was pre-submitted and included in the packet can be displayed on the screens for reference as needed. We will begin with statements from the applicant. The board may ask questions as the applicant presents. Then the city will have an opportunity to present, and again, the board may ask questions. Both sides will then have the opportunity for rebuttal and closing statements. Any witnesses called by either party will be sworn in by our court reporter and may be cross-examined by the other party before proceeding. Is the applicant or their guest or agent present? Thank you.
Sure.
Yes. The floor is yours.
I'm Jeff Linker, Granite Property Management Company. We manage Creekside Villas, which is at 800.
No, just go ahead and.
Thanks for getting together tonight. It looks like I'm the only person who ruined it.
No,
so
no.
It's take too long. As I read the code and read some correspondence from Mr. Young, I understand your position has to be, in order to appeal, there has to be a couple of clear reasons, and I'm citing too that I think the intent of the code could have been misinterpreted by the enforcing officer, and I also think that we have context of this law, some special circumstances that the code may not fully apply to our property, at least right now. It may in the future, but at least right now, I don't think it should or does. And I'm hoping everybody read the 2-page submission that I sent in online, so I don't need to sit and read through all that. You can probably tell where I'm coming from. But to stay here in the meeting, one of the things that I received from Mr. Young was an email because he was explaining how the city came about putting the law together, the legislation together, and said the city got input from emergency services, and rather than tackling all apartment properties, they said to the emergency services, well, where should we start? And emergency services said, quote, buildings with 8 or fewer units. And so that's how the law was drafted. And not to be too presumptive, but to me it seemed like, putting my hat on as emergency services, 8 or fewer units in a building is very different than 8 or fewer units in a property. And I felt like, and I haven't called anyone in emergency services, I haven't talked to anybody, but it seems to me that the problem areas in rental communities would be the smaller properties, 1, 2, 3, 4, 5, 6 unit little properties, that's all they have in the entire property, a duplex, a triplex. They're not professionally managed. If we probably check statistics, that's probably where most of the problems are that the emergency services are encountering. Not large, what I call our property is a large professionally managed property. And so I felt that when the word building was put into the actual code, it frankly almost seemed like a mistake. That what does the size of a building have to do with it? Property is one thing, but a building. We happen to have 19 buildings that are 6 units each, 7 units each. What does that have to do with emergency services and problems and issues that are on smaller properties of 5 units? And if you interpret the code literally and tell Creekside Villas, yeah, you need to sign up, you need to pay the fees, you need to be inspected, you're part of the problem. But wait a minute, the property down the street with 200 apartments, or 50 or 100, whose buildings just happen to be 9 units, 10 units, 12 units, they don't have to do it. And to me, that just doesn't, that's where I'm getting at the intent of the code, that I feel that the intent of the code was smaller properties, not buildings. I keep going back and forth on those words. But hey, we got to get after the smaller properties in the city that aren't professionally managed. You don't have staff. And there's problems, whatever the problems are. Maintenance, crime, whatever. But our property doesn't have those problems. You can talk to emergency services. We did ask them. This is my property manager, Deb. She has talked with some of the police in the city, and they've told her your property is not a source of problems. It's not a problem property. We've spent millions of dollars there since we bought it. We have full-time staff, manager and maintenance tech, 40 hours a week. We're just not a problem property in any way. And so that was the first part that I thought, kind of getting to the intent of the code, it seems like coming after Creekside right now. And by coming after, I mean forcing us to comply with this right now. To me, doesn't seem like that was the intent of the code. Second of all, special circumstance gets to the second part of Mr. Young's email to me, where he was explaining that, well, the city's original intent was ultimately to do all apartments in the city, which we could debate that all day. You guys probably did for months or years. I feel that's excessive, but whatever. If that was the intent, that's not how the code was written. The code was written with this oddball 8 units or less per building. It doesn't say all apartments. So right now, the way that code is written, no matter what the future intent is, the code says what it says. And to me, I don't see how anyone can explain why we would be cited and have to be part of this program right now because we have less than 8 units in our buildings, when all these other properties that just by luck have bigger buildings, and by the way, could be actually problematic. There very well could be communities who have crime and drugs and all kinds of things going on, but just because their buildings are 10 and 12 and 20 units, they don't have to sign up. They don't get a violation. It just doesn't make sense to me. And so that's why I felt that you could actually look at the special circumstances part of your appeal, that we're a big property. I don't think we were part of the original plan. And unless you can rationalize why other properties with more than 8 units don't have to comply, and we do, it just seems that perhaps we should not have to be forced to do this right now. It's going to be a lot of expense. It's going to take Deb and our maintenance person a lot of effort to comply with this. I've never owned a property. I've been doing this for 30 years. I've never owned a property anywhere where every apartment has to be inspected. Unless there's a problem. I think it's going to be hard frankly, for the city to even do it, but for all these buildings. But in any event, until the day arrives when the code is written, it says, every apartment has to do this, and we're issuing a notice to every apartment, and everybody needs to sign up. I would like to, take a position that Creekside, unless there's something I'm missing, that Creekside should not be forced to do this right now. So that's everything I have to say. If you have any questions, I'm more than happy to answer them. Anything about the property or the company or anything else.
Thank you, Mr. Linker. Does the board have any questions at this time for Mr. Linker?
I have a question. Do you have an estimate on how much it would cost for you to pay the fees associated with registering each unit required?
I think it's
It's $5,000.
about $5,000.
That's fine.
And I think it's either gonna be every year or it might, I don't remember if the code said something about, you might be able to get by with every few years.
Yeah, I know it's contingent upon the
But then you
result.
still pay a
Right.
per inspection fee on top of that, right? So
Correct.
When someone moves out.
when someone moves out, so we
Yeah.
probably turn 35, 40 apartments there a year. That'll be another like $50 per turn. I'm not just standing here professing that that's gonna break this property.
Sure.
I'm not trying to say that. But it is an expense that to us just, I mean, if you came and inspected, you could pick any unit in that property other than maybe, you might have one little old lady order. I'm not sure that we just keep letting her do her thing. But other than that, our properties are nice. I mean, there's just nothing wrong. Lenders, we have a Fannie Mae loan. They come every year. They can never find anything. I mean, they're pointing out, you got a crack in your sidewalk. That's about where they come up. So, anyway, and again, if obviously it's not time to do something like this in the context of this appeal, but I mean, the city, Mr. Young, or any of you wanted to come to the property, absolutely be our guest. You can show up whenever you want. Dell will show you around.
I have a question. Do you have a full-time maintenance person on the property? I mean,
Yes.
do you actually employ them? Or are they
No,
subcontracted
they're
out? Or
employees. Deb is an employee of the company. Mike's been an employee. Mike's actually been at that property for 8 or 9 years now. I have very low turnover. We do all our own maintenance other than things like grass cutting and snow plowing and stuff like that. We contract that.
Mhm.
Of course, if you need a plumber or something, you call. And that's how I run all of our properties. Everybody has full-time staff on site. And that's kind of what I'm not trying to, act like I'm on city council or I'm on emergency services, but I'm putting myself in those shoes a year or two ago. Thinking, what were they really going after? What was the problem? What were the source of these problems in the city with maintenance? This is a maintenance review board. Properties that are worn out and have violations and people don't fix them and all those things that you guys wrestle with. And I'm like, it couldn't have been a property like us. And what does 8 units have to do with anything? I mean, honestly, if I just happened to have had 12 unit buildings, I never would have gotten this letter. And that's what I struggle with.
I have one other quick question. Did you receive any notification from the city prior to their visit that prompted this, that you would be
Wait, I'm sorry,
required?
say again, did you?
Sorry, speak louder. Did you receive any notification from the city prior to, and it's my understanding, Ben, correct me if I'm wrong, that what prompted this was a number of visits by emergency services? Prior to that, did you get anything that says, hey, by the way, you're a property that's required to register?
So prior to this appeal and this violation, we got an initial violation letter from the same inspector to comply with the exact same program. And that violation letter cited, you've had too many visits. And so I filed an appeal and I gathered some statistics on visits. And I analyzed what the visits were. And I wrote a similar letter and submitted it all online. It's going to come to an appeal. And then it got changed, and all of a sudden, it was, well, wait a minute, let's not do that, let's do the 8-unit thing. So, and on that one, to be honest with you, again, I'm not a lawyer, I don't write law, but that law I had some issues with because the way it was written, again, was very simplistic. It said, if you've had six visits, no timeline, no, what if it's 6 visits in a month or 6 visits in 5 years? Well, does that seem fair either? That if I'm the guy who has 6 visits over 5 years, all of a sudden I'm in the program, but maybe a guy down the street has 5 visits in a month, and he's not. Like it seems like there should be a timeline: 6 visits in a year, 6 visits in 6 months. I don't know. And actually, so on that, I don't know if anybody got that or read it. I actually looked at the visits we had, and I mean, we had a person sleeping in a car. We had a tenant who couldn't find his keys. I mean, we went through the list, and of the entire list,
Welfare check.
there was welfare checks. Somebody called the police because they couldn't get to a senior citizen. That's a visit by emergency services, but it's not a potential, threat to the city. And of the entire list, out of I don't know how many visits it was over a year, there were 1 or 2 that I guess would fall under, it could have been a problem. There was like the lady who said, I saw someone walking through the parking lot. Okay, well, police came, nothing, we didn't find out who it was, we don't know what happened. I think there might have been one kind of real bad thing where
A catalytic converter.
someone stole a catalytic converter. So we had one true crime type.
And some of them were just the police pulling people over in our parking lot on it for
So I think, again, even under that criteria, I felt that we would, maybe a special circumstance. But other than that, no, we don't get letters from the city on violations, on, hey, you've got a problem here, hey, we've got suspected, drug dealer in your property, or, we getting calls on loud, we didn't get loud noise or anything. So, because we're pretty strict. I mean, I manage 1,100 apartments in Ohio. And we, in the course of a year, across our entire portfolio, we might evict 1 or 2 people. And that's because we basically we get them to leave before we even have to evict them. If you're causing a problem, my theory is, look, you're gonna want to go live somewhere else. And they kind of we pride ourselves on the fact that we're safe and I think well managed. I don't know if anybody looked at our website, but we've had Creekside now for 12 years. It was a wreck. If you knew the property or not. It was pretty bad. So we're kind of proud of it. And Deb does a great job. So that those are my requests on what, to be, I guess, exempted from this, at least until either there's a reason, I guess if we had a really ton of problems, or B, if the city does decide to pass a global, truly global, every apartment has to do this, and then I wouldn't have a choice, I guess. I mean, there would be nothing to appeal. If you make everybody do it, then there's nothing to appeal.
Any other questions? Good. Thank you, Mr. Linker. Appreciate it. Does the Department of Development Services wish to present anything?
Good evening, everybody. My name is Wayne Boyer. I'm the Director of Law for the City of Canton, and I will be presenting on behalf of services. One item before I start, just for purposes of preserving the record, a few comments on the record, and so just for the purposes of making the record complete, could you please identify yourself?
Deborah.
Can you spell your last name?
Gambo.
And you know, they weren't sworn. You want them sworn?
Probably should.
Can I just have you both raise your right hand? Do solemnly swear that the testimony you have given or will give truth, the whole truth, and nothing but the truth. Thank you.
Thank you.
Sorry about that.
Thank you. Okay, so we heard Mr. Linker present, and ultimately a good portion of what he presented, while potentially factual in nature, doesn't really apply to what the board's purpose is here this evening. So the North Canton codified ordinances allow for this board, pursuant to Code Section 703.100, to decide 3 very, very specific issues related to the application of the property maintenance code. And those issues are whether the intent of the code or rules have been incorrectly interpreted, which Mr. Linker did bring up, whether the provisions of the code do not fully apply, or whether the requirements of the code are adequately satisfied by other means. So that's it. Those are the only items that this board is authorized to review. So importantly, all 3 of those powers come from the same place. They start from the same place. And that place is, they assume that the code in general is enforceable, and now you have to interpret that code as it applies to the property owner. Here, in certain circumstances, and I just want to clarify, it sounds as though the appeal here isn't towards the application of the code, it's to the code itself. There's some objections to the code itself as far as the validity of the code, potentially constitutionality of the code, in reference to thinking that it should apply throughout the entire city to every property owner. Those issues, this board is not authorized to decide and can't decide. I can't decide it. Nobody in this room can decide it. Those would be issues for the Stark County Court of Common Pleas to decide in a separate action. So here, what we're left with is just deciding those 3 specific issues related to whether the intent of the code or rules adopted thereunder have been incorrectly interpreted, whether the provisions of the code do not fully apply to the appealing party, and whether the requirements of the code are adequately satisfied by other means. Those are the 3 items that we're going to address here this evening. At the outset, in relation to the intent, we heard from Mr. Linker concerning, his presumptions as to the intent, if he put on his EMS hat, if he put on his attorney hat, if he put on these hats. Respectfully, what I would say there is that the intent of the code, the interpretation of that code should be made by those who actually established the code. And those who established the code are, there were discussions related to the establishment of the code by several parties in relation to the city, and then it was ultimately passed by City Council. And so to get at some of the intent behind the code, what I'd like to do is call Patrick Diorio, the Director of Administration to the City of North Canton, to the stand.
Where that stand is, stand right here.
You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Mr. Diorio, I believe I just said it, but please, can you confirm what your involvement is with the City of North Canton?
Yes, I am the Director of Administration for the City of North Canton by charter. That responsibility places me as the Director of Public Safety and the Director of Public Service.
And in that capacity, were you involved with the creation and or implementation of the rental registration program?
Yes.
And how, can you explain how you were involved?
Well, as the Director of Administration, everyone in the city reports to me. And so the City Council had, over the years, tried to get rental registration programs established. I became the Director of Administration in 2018, and as a result of that, and putting together the various departments and bringing in other employees and outside contractors together, formed a team to analyze how we would go about accomplishing council's request to establish a rental registration program. So with that, we studied what went on around municipalities throughout the country, throughout Ohio, throughout Stark County, and then from that basis of how things work elsewhere, then spoke with individuals here, code enforcement officials, police officials, fire officials, on what the particular needs of our municipality.
And did you have a meeting or meetings with these team members prior to even presenting anything related to the code to council for review?
Yes.
And who participated in those meetings?
Been myself, chief of police, the head of the Fire Prevention Bureau, Mr. Van Gundy from the building department, myself, Mr. Young from City Council. I believe you as Director of Law constituted members of that meeting.
And when you were in that meeting, did you request input from the police department, from the fire department, from the EMS department related to what they saw in the city for issues related to rental registration?
Yes, I did.
And what kind of feedback did they give you?
The feedback we focused on all types of rental properties, from single-family homes all the way up to buildings with lots of units. And the consensus of opinion from the police department was that, in their opinion, that buildings with 8 or fewer units were the buildings that presented the most problems to them.
And to clarify on that did it matter as far as the number of buildings per property when they gave you that feedback?
It did not. We specifically discussed that and made it clear whether we were talking how many units per building or how many units per property.
And to clarify, just to make sure I understand, regardless of how many buildings were on the property or at each property, ultimately the feedback that you received was that the units of most concern were those that contained 8 or fewer units.
Correct.
Was there any reasoning given as to that aspect as far as why those particular buildings were more interest and more concerned than the larger building?
I think this is my recollection of that at that time, was that in their responses, they note that properties of that size are more prone to certain types of unwanted behavior, whether it's domestic violence calls or other outright criminal case calls, disturbance calls of some kind that get them in, that those size buildings would represent the greatest issue to them because of their size and how many people are in the building, and from a logistics standpoint, executing a response to that.
Do you recall approximately, I don't need an exact number, how many meetings that you had in relation to the code in general with your team?
Well, I would say from start to finish, more than a dozen meetings. This was something that occurred on a regular basis, every couple of weeks, tackling a piece of it, writing up something, reviewing it, coming back, adjusting, starting the next piece of it, and it went on for the better part of the year.
And then ultimately, at the conclusion of those meetings, what was the next step in relation to the code?
Well, ultimately, when we felt that we had reached a final draft and that all parties on the team had signed off on what we believed to be a final draft, then that final draft was presented to City Council for their consideration. At that time, you know, no member of city council was involved in the drafting of this. The administration's responsibility is to draft language, and it's up to the city council to debate it, tweak it, and ultimately accept it, modify it, or reject it. It was presented to city council, went through a number of public hearings. There was a lot of input from audience participation, members of the public, members of business establishments speaking out on it, substantial debate among council. And it was clear from what council had passed. Ultimately, I believe it was on a 5-2 vote to move forward, 2 objections. Had some, whatever the reason, they said no, but ultimately it passed. The mayor signed the bill into law, and then it was our responsibility to execute.
Was there any lag time in between the passage of the bill and the implementation of the program?
Yes, there was. And so we felt that, as this was a new venture for the city, that it was important to give property owners sufficient time to be able to implement. So it's my recollection that the program was passed and signed by the mayor in May of 22, and then we gave a January 1st, 2023 start date. Registered by, and then I believe we went from January into like March, 60-day period to kind of get everybody else in, and then the window kind of closed at that point.
So ultimately, the property owners had from May of 23 until roughly, or May of 22, excuse me, thank you, sir. May of 22 through March of 23 to digest the law and begin the process, at least, of attempting to get their properties in compliance.
Yes.
I have nothing further.
Am I allowed to ask?
Yes, yes, sir.
So I'm curious, as you went through the process to craft this law, did you actually run any statistics at all on problems, emergency calls, crime statistics, whatever, all the different things you cited? Did you run any simple reports on all the apartment properties? There's not that many big ones, by building size in particular, or at least by property size. Analyze anything with more than 50 apartments to back up this discussion of, oh, well, 8 or fewer units in a building. Were there any statistics that run at all or analyzed?
The information that we analyzed was given to us by the police department based on their experience providing public service to the city.
But it was just input. There was no statistics, there was no data, there was nothing to support. Why would you pick eight units a building? Other than just somebody said that, or I guess I just don't understand how that number, which throws one property into a category and everybody else out of it. If there's no statistics other than who used that number in all your meetings and reports. But I guess you answered the question. There was no data that supported the input that 8 units or less is a problem. That pretty much summarize it.
I would say that I relied upon the police department's and the chief of police's knowledge and experience in running a department, determining what properties are ones that they're most concerned
Okay. I would feel that some data or statistics might matter, just like when you decide whether.
Is that a question?
If you're gonna cut a curb, you do a traffic
Objection.
study.
Is that a question?
It is my question is, why wouldn't you get statistics or data? And on anything else the city does, there's traffic reports, there's studies, there's all kinds of data,
Objection
statistics.
calls for speculation.
Okay. Next question. Was there any discussion, as you put the law together, was there any discussion or input about size of property? Not size of building, size of property. And did the city and the group that was putting the language together and the code together discuss at all the disparity that's potentially created where certain properties are just not going to fall into this, even though they might be problem properties, they're not going to be subject to this law because their buildings have 9 or more units. Was that analyzed or discussed at all?
Size of the property was not subject to a discussion.
Do you think it should have been?
No.
Also, we weren't notified until March of this year. So if the law went into effect on January 1st, we weren't notified until Benjamin Hicks came into my office and handed me a letter in March of 2000.
I'll ask the question that follows along that thinking. With the amount of time that you mentioned in the lags of writing of the law and implementation, how does the city, once that goes into effect, notify every property owner in the city of North Canton that meets this criteria of 8 units or less? They are required to register. How were they notified?
I can take a shot at it. We as this had not ever been done before by the city and given input from the communities, we made contact with the Stark County Auditor's Office and used their database as the starting point. And they keep a record of rental properties. In this particular instance and other instances, we supplement that with observations of individuals driving around the community and looking to see that every property that would appear to be a rental would be then given that letter, because we've determined that the county's records weren't completely accurate. They left properties off. And so I took that responsibility upon myself to drive the entire city with the code enforcement coordinator and to look for said property. So I may even have been the one that pointed this out, that 800 Everhart, asking, is this going to register? Period, the number of units in the building should be in compliance with our code. As I did with Northwood Apartments.
Say again.
As I did with Northwood Apartments and another one on North Main, and I can't remember, next to Papa John. Apartment complex there that also had 8 units or less, but didn't appear on the county records, and we had.
Just a few follow-up questions based on these questions. How long has your chief of police been the chief of police in the city?
Approximately 2 years as chief and at least a dozen years as sergeant in command position.
And when he was sergeant in command, that was in the city, correct?
That's correct.
How long has the director of your fire department been employed by the city?
The superintendent of the Fire Prevention Bureau has been with the city almost 30 years.
In the fire prevention or fire department? And how long has the director of EMS that was participating in these meetings, how long has that individual been employed by the city in that capacity?
Approximately 25 years.
Would you have any reason to doubt those 3 individuals' experience in their respective departments related to the their recommendations for this program?
No.
Thank you. Nothing further.
I have an additional question regarding the code section 703.04A, where it talks about the number of calls to and or visits from the North Canton Police Department. Can you define what a visit is? I know that the appellant mentioned, somebody getting pulled over in the parking lot. Does that constitute a visit?
Well, may I interject on this, that the letter in question for this appeal had nothing to do with any sort of emergency visit, any sort of police visit. The citations that were the subject of this appeal were in the May 15th, 2023 letter, which simply lists, it's part of your packet, it simply lists that this property is identified as a rental property with 8 or fewer units per building, and any building that contains 8 or fewer units or is the subject of 6 or more calls related to potential violations of Part 5 of the codified ordinances shall be required to apply for the license. The reasons given in the citation were that these buildings contained 8 or fewer units. In the citation that is, and I apologize for interrupting.
No.
In the citation that is at issue for this appeal, there is no mention whatsoever, other than the citation of the code, of the 6 or fewer visits.
I understand what you're saying. My question would be in response to that, how was the property identified to be in violation? Was it that they did not respond to an initial inquiry with the auditor's office where they were identified to be responsible to register? Or were they in violation because they were identified through the number of visits?
I believe that Mr. Diorio just indicated that on the record, that the way they were identified had to do with the number of units per building, but I will verify that statement. Mr. Diorio, I believe that you just said, and please correct me if I'm incorrect, that you were driving around with the code enforcement officer and identified this particular complex as having buildings with 8 or fewer units. Is that correct?
That is correct.
Thank you.
I have one question. I understand that Creekside is managed by one property management company, yourself, and that the buildings are separate, that they're not connected, correct? But had those buildings been connected by some other means of a walkway, joining roof or something, would that still apply as a separate building? Even though that they would be connected by some sort of...
From a speculation standpoint, I'm not sure that we can answer that because there's several different ways that you could be connected. If it's one interconnected building with hallways throughout, you could certainly argue that that's one building.
Well, that's what I'm asking, and that is...
If it's a skywalk or something, where it's simply a corridor that is covered to get from building A to building B, I would argue that that's a separate building. So I think that, and that's not really, I'm not interpreting the code here. I think that'd be a question more for the Director of Development Services. But ultimately, I think that speculating on what could and couldn't be under the purview of the code may not be appropriate in this instance. But I think that that could probably go either direction depending on the method of connection.
Are there any other apartment complexes within the city that have the unique design like Creekside does?
Yes, there are. There are a number of other apartment locations that have multiple buildings. Northrop Court, I believe, has 16 separate buildings that are 8 units or less. Remember the name of the one?
Center Court.
Huh?
Center Court, I believe, is what you're thinking of.
I'm thinking the one on next to Papa John's.
Bedford Place.
What is it?
Say again.
Beckford Place. Beckford Place has approximately 15 buildings with 8 or fewer units in each, all separate buildings.
But those
Mr.
are the other ones.
Mr. Van Gundy, since you just responded to something, would you please identify yourself and swear yourself in?
You solemnly swear that the testimony about it will be the truth, the whole truth, and nothing but the truth. Thank you.
Okay, so moving on to the code sections themselves. Part of the analysis here that's in front of the board has to do with whether the intent of the code or the rules adopted thereunder have been incorrectly interpreted. So I want to take a brief moment, and I will do my best not to bore everybody to tears on this, but just to go through the code sections very briefly to determine the applicability in this scenario. So in section 70302 of the code, it defines rental units as any premises or portion thereof containing units being occupied, intended to be occupied, or designed to be occupied for residential purposes by a tenant or person in like circumstances of a tenant. Section C, premises, means a lot, a plot, a parcel of land, easement, or public way, including any structures thereon. And the owner is any person, agent, operator, firm, or corporation having legal or equitable interest in the property, or recorded in the official records of the state, county, or municipality as holding title to the property, or otherwise having control of the property. And so what I'd like to do is to introduce one exhibit onto the record. I'll identify this as Exhibit 1 for the city.
Thank you.
And Exhibit 1, what you have in front of you is the deed of record, the most recent transfer of record related to this parcel, as well as the tax card for this parcel. You will note that both the tax card and the deed identify Creekside Residential Partners LLC as the owner of the property. And please note that the notice of administrative warning that was issued to Creekside Residential Partners LLC. So based on that information, and also based on the appellant's own documents that related to this appeal that indicate that they are the managing company of Creekside, that Creekside contained, I believe it was 19 buildings that each contained from 4 to 8 apartments located on this property. We can go through section 70303 and 7034A in relation to see if what was cited by the code officer is a correct interpretation of what's in the code. So going through 70303 first, and we'll read directly from it. So on and after January 1st, 2023, which we have here, this was issued on May 15th, no owner, agent, or person in charge, Creekside has admitted that they're the owner of the property, of any non-owner occupied building, Creekside admits that these properties are apartments for rent, of 8 or fewer rental units, Creekside admits that the maximum number of apartments, rental units in each building is 8, shall rent or let for occupancy such units or any part thereof for use as rental or residential or temporary occupancy. Again, they've admitted that these are apartments used for residential occupancy. Nor shall a person occupy such premises unless the owner thereof holds a rental license and a rental license has been issued for the unit by the director of permits, which license has not expired, been revoked, or otherwise become null and void. And that's why we're here, because there hasn't been a rental license obtained. So based on that, we seem to meet all the criteria of section 70303. So now we go to 70304A. Any building A containing 8 or fewer rental units. Again, we have here that Creekside has admitted that the maximum number of apartments in each of their buildings is 8, so it by definition would contain 8 or fewer. Or B, that's the subject of 6 or more calls to and visits from the North Canton Police Department related to potential violations of Part 5 of the Codified Ordinances of the City of North Canton. That's not applicable here because that was not cited in this letter. Shall be required to apply for and maintain a valid rental license. And again, they have not done so. So that's why we're here. Based on those two readings, accompanied with what's of the record, what's in the appeal, documents that were submitted, there can't be any doubt that we meet the criteria there, that we're in violation of those because we've gone through and established that each of those items are met, yet the rental license has not been applied for, and they're currently operating these as apartments. So as far as the the code enforcement officer misinterpreting the statute, I don't see how you could possibly find that particular interpretation based on just going through it one by one. Whether the provisions of the, and I apologize, let me go back. Going back to the 3 items that this board is authorized to review in relation to an appeal. 1, whether the intent of the code or rules adopted thereunder have been incorrectly interpreted. We just went through that. 2, whether the provisions of the code do not fully apply to the appealing party. Again, those 2 are somewhat related here. It would appear based on the Creekside owning buildings, which if the word building is there, it's not property, it's building, containing 8 or fewer units. Again, what Creekside has indicated that is the makeup of their buildings. We meet that section, it's got to apply to them. So the third and the last item that we have to look at is whether the requirements of the code are adequately satisfied by other means. Now again, we look at the appeal and the language provided both in the appeal documents and by Mr. Linger this evening. And their appeal contains what their assumption is to the intent of the code, time and cost related to complying with the code, comparison of their properties to other properties that aren't the subject of this appeal, aren't subject to Chapter 703. Statements from them that they're not the problem you're trying to manage or control. Revisions that they would propose to Chapter 703 had they been on City Council or involved. And a proposed interpretation of email comments from Mr. Young that attempted to answer questions. None of that contains any sort of special circumstance or as to why they shouldn't be subject to the code. The one item that does even mention special circumstance in the appeal was the blanket statement that Creekside is certainly not what emergency services wanted targeted for the first phase of this program. We know for a fact that that's not accurate based on the testimony of Mr. Diorio in the multiple meetings that were had that specifically decided through that process, through City Council, through 5 meetings where it was read, debated, public comment was invited by both Creekside and any other member of the city as to this procedure that was being established. Throughout that process, the number 8, the building, the definition of a building containing 8 or fewer units was part of this. The intent of 3 officials with a total of roughly 50 to 60 years of experience in the city identified that 8 or fewer units for buildings containing 8 or fewer units needed to be a part of this because in their experience, those buildings were the buildings that were most likely to be subject to problems. That does not comport at all with the idea of the supposed special circumstance that Creekside is certainly not what emergency services wanted targeted for the first phase of this program. And I would submit that I have no reason to doubt any of the statements on the record this evening that Creekside is a first-class, first-run, high-rate apartment complex. No reason to doubt it. I've driven past it. Gorgeous complex. Which would beg the question, what would the issue be with complying? Because ultimately, to treat everybody fairly that's in the same situation of those sites that are identified as the most likely sites to be problematic, every site that has building or buildings with 8 or fewer units must be subject to the code. And if you've turned out that you have no problems, that the inspection comes in, takes 10 minutes, you get a check mark, sign off, you pay your fee, you're registered for 3 years, and we're not going to come back because now we've identified that you have properly comported with what we're trying to accomplish here, which if we go back to the very beginning of the Property Maintenance Code, Section 70301, one of the main purposes is to provide a safe and sanitary environment for the residents and their guests within the city. That's what we're trying to accomplish here. That's why the code is written. And that's, quite frankly, why the code itself is written the way it is because in order to establish that, and based on the experience and the recommendation of a number of people involved with the city, those were the items that needed to be addressed. Those were the buildings that needed to be inspected. So ultimately, the time to raise any of the issues with the code that were raised by Creekside is not now. It was during the public meeting process that began in April 2022.
Of which we were not informed.
Right.
Of which we were not informed, or I would have been there. So, for the record. We pursued a law. My guess is there were hardly any owners of properly maintained properties in the town were involved. Or did you seek our input?
I'd like to call Mr. Ben Young to the stand if I could, please.
solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Mr. Young, what is your title with respect to your employment in the city of North Canton, Ohio?
I currently serve as Director of Legislative Affairs and Clerk of Council for North Canton City Council, and then as a Public Policy Analyst. Tonight, I'm in an interim capacity serving as clerk of this board because of a vacancy in the position that normally serves.
In relation to your duties as Clerk of Council, what does that entail?
Largely the preparation of meeting materials for City Council. For most legislation, I would describe it that I am strictly the author and that I write the words on the paper, but generally somebody else is formulating the policy that my job is simply to put it into words.
And once an item is ready to be placed on an agenda for any city council meeting, is there a process that is followed in order to make that particular piece of legislation, whatever it would be, available to the public?
Yes, so we're required by Ohio Sunshine Law to post public notice of all public meetings, and it has been, and as long as I serve as clerk, will continue to be tradition in North Canton to go above and beyond those legal requirements and publish the entire agenda packet that the council has for public consumption, roughly every Friday at about noon before Monday meeting.
And with relation to the meetings that were had for public consumption related to the rental registration component of basically what we're talking about this evening to establish the rental registration, were those publication requirements followed?
Absolutely.
And so, in fact, as of right now, if I got on the City of North Canton's website, would I be able to locate those?
Yes, they're permanently archived on our website.
And so for each of those meetings, was that notice given pursuant to your normal standards of publishing the Friday before these meetings online?
To the best of my recollection.
And does that meet the requirements of Ohio law and Ohio statute concerning publication of items for consumption at a city council meeting?
Absolutely. The minimum requirement is only 24 hours. And by publishing on Friday before Monday, we easily meet that burden.
Did you treat the publishing of this rental registration ordinance any differently than any other piece of legislation that you would publish?
No, it would have been included in regular agendas along with other legislation that was being considered that evening.
So ultimately, each of those publications would have included whatever was on the agenda for that evening, whether it be rental registration, whether it be any other ordinance, any other resolution, all of those would have been contained on the same agenda for any meeting, regardless of subject matter.
They would have appeared on the agenda, and the full draft text would have appeared in the PDF packet.
It's a full draft text of what was proposed for rental registration purposes was available online to anybody prior to each of these meetings.
Correct.
No further questions.
I have a follow-up question. For the people who were originally identified, these are not people, properties originally identified as being applicable to this ordinance when it first was written and implemented, was a notification sent to those people, or was it expected that they would go online to the city's website and find this new law? Were they sent a notification?
So as Director DiOrio alluded to earlier, we did our best to identify all properties possible. So we used, there's a separate state law that rental units are supposed to register with the county. So we started with that database. It was small. So then we used our zoning code and the auditor's building code. So they have codes that define what they believe a property is being used for, and cross-reference that with the listed owner of the property. And any property that was considered residential by both us and the county, but the owner did not list themselves as residing at that property, and that was listed by the county as having 8 or fewer units, got sent 3 early warning letters prior to January.
But nothing regarding the legislation, the drafting of the legislation or the meetings. I think that's what she was asking.
Now I'm just asking, when this was a brand new ordinance, was there anything sent to people like, hey, heads up, brand new thing here that you're gonna have to do? Or we just waited until they violated something?
To everyone we could reasonably identify, they received up to 3 notices. We allowed people to register early. If they registered early, we stopped sending them
Okay.
notices.
Mr. Young, is there a requirement that you're aware of under Ohio law that for any ordinance that you
I'm
pass?
sorry,
you have-
Wayne, can you say again? Is
Yes,
there-
not a problem.
Sorry.
Is there a requirement that you are aware of under Ohio law that you identify any potential owner that could be subject to any piece of legislation that you draft and send out a notice to them ahead of time, letting them know that there is a piece of legislation that may affect them in the future?
No, the only requirement close to that is our city charter has a requirement that if it is a specifically identified address in the legislation, I must send notice to that address. But if it is broad legislation that applies citywide, there is no obligation to specifically notify persons who may be affected.
And is there a scenario that a piece of legislation that is included in the packet for any particular meeting may not in fact be passed?
I'm sorry, I don't understand what you're asking.
Is there a scenario where something that is presented to council for consideration to pass into law in a packet that you would put in as far as the city council agenda, is there a situation, is there a possibility that that particular piece of legislation would not ultimately become law?
Oh, absolutely. Council has ultimate authority to approve or deny the legislation, and even if they say yes, the mayor could veto.
So ultimately, there are 2 separate ways where a proposed piece of legislation may not even become law, such that any sort of notice related to it would be futile. Or unnecessary, excuse me. Futile is probably a bad word. Okay. Nothing, Brent?
I have a follow-up question to that. For anybody who was not part of the originally identified population that the law was applicable to, I hear that we have people, I guess, Pat, I think you said you drove around in a vehicle, right, to identify a property, and I assume that still goes on today. Do we identify that property and say, hey, this is not on our original list? Let's go ahead and send them that notification, not of violation, but notification that this applies to you and you need to register, or do they immediately receive a notice of violation? Does that make sense?
From my understanding of the code, they receive a notice of administrative warning
Okay,
before they are found in violation, and they are given a 30-day grace period to comply before getting a violation.
thank you.
I have one quick question, and I don't know if this is out of line, but is there any current issues before city council that impact this particular code?
As of the final council meeting this past Monday, there are only 3 ordinances on the docket, and none of them address rental registration.
Okay, thank you.
I have one quick follow-up to that. Has there been any amended language in this ordinance since it originally passed? Has anything changed? I'll go back to, ahead.
Yes, there have been 2 amendments to my recollection of this legislation. The first was in November of 2022, before the ordinance took effect. Language specifically regarding whether it was 8 per building or 8 per property was amended to clarify it. So the administration requested clarification because the responses to some of those initial warning letters were that it was confusing. So they proposed language to city council to clarify even more that it's 8 buildings. The second amendment was enacted after the legislation took effect. I want to say March of this year. We received feedback from property owners that the number of inspections was overly burdensome, and the time between inspections was too short. So council amended it that there are now fewer inspections and more time between inspections to correct violations.
Thank you.
So just to be clear, and I understand the city can't send a letter to everybody who might be impacted by the law. If you're going to pass something that impacts a lot of people and businesses, your expectation is that everybody should jump on the internet every Friday and read the agenda of every council meeting, just in case my business might happen to be impacted. That's the premise of notice. I know it complies with sunshine law. I just want to make sure that's what I'm expected to do. Yes, correct. Every Friday we gotta get on and make sure there's nothing up for council that might impact our business. Okay. And just for the record, again, I don't know whether this is a question to him or to you, that in the process of creating a fairly widespread law that impacts a lot of businesses and a lot of property and a lot of people, the city did not consider contacting or getting input from anybody in the property management business, whether they own property in Canton or not, did not get any input from anybody in the property management business, people that actually do this for a living. You did not do that. Or B, you did not solicit input from any property owners.
Wait, excuse me, we can only talk one at a time. So, you did not do that, or B, you did not solicit.
Or you did not get input from actual property owners who happen to have, let's say, larger properties, whatever larger means, 25 units, 50 units, 100 units, I don't care. You didn't, and 3, you did not.
Ask that question so that you can get an answer before you ask the next.
Okay.
Go ahead, Mr. Young.
So to my knowledge of consulting with outside parties, when I was asked to begin drafting this legislation, I was provided a white paper from the National Association of Realtors that I was told was given to us by the National Association of Realtors as what they would like to see in a rental registration program. And then the Stark-Trumbull County Association of Realtors were present at, and members of that group spoke at, they were present at all 5 public meetings that this was considered at, and they spoke at all 3 public meetings that public comment was permitted. And then I know from my capacity monitoring council's emails that they received well over 50 emails from members of the Stark-Trumbull Area Realtors Association with comments related to this ordinance.
One note on that.
I'm a member of the STAR.
One note on that, realtors, by definition, sell homes. They do not professionally manage property. So you can get all the realtors in the world. They might manage a house or a duplex or 2, but realtors.
Objection, is this a question or testimony?
It's testimony, and
That's not what you're doing at the moment.
I'm clarifying, well, I guess I'm clarifying the record that it's all great that you brought a bunch of realtors into the picture. I'm just making a point that realtors are not professional property management companies. There are dozens of them in the region. I'm just one that could have been brought into this picture, but you didn't. So the second question was, You didn't solicit input from property owners in North Canton who have larger properties, correct? Is that correct?
I am not aware of if we explicitly solicited input or of those who gave input, the size of properties they may or may not.
And the other thing I find interesting is, just to clarify, that in the process of creating a law that impacts a number of properties, in particular specific types of properties, you didn't bother to run any of the reports or stats before you drafted the law on who will this impact? Which properties does this matter? Which properties qualify under these guidelines? That was all done after the law, when you had to figure out who do we send a letter to. None of it was done before. There was no identification of, hey, if we craft a law that says this, who will this apply to? Was that done beforehand?
Yeah.
And were we identified?
I would have to look.
It's
No further questions. At this time, I would just like to reserve some time for closing argument.
Thank you. Thank you. Does the board have any other questions at all? At this time? Okay. Thank you. Mr. Linker, if you would like, you can give your rebuttal or your closing
That's okay.
arguments.
I have just a couple of comments. So if we weren't notified until March of this year, it was already a warning or violation. The 3 letters that went out before January, we never received. And also, I know that there was still due diligence that these letters were mailed, because the ones we started receiving in March of 2023 were handed to me in person, mailed to my office, mailed to Mr. Linker's home address, and also to his office. So we received none of that before the law was put into effect. And then we weren't notified until March, after it was already in effect. And then we had 30 days from that day to inspect 108 units and pay $5,000.
Well, in response to that, Mr. Young did clarify for me that, in fact, the city would not expect us to get all of them inspected within 30 days. I believe you told me that we have to register within 30 days and then schedule the inspections over some reasonable period. I think is what. So that, our interpretation of, oh my gosh, we gotta do all this in 50 days was not,
Okay.
which isn't real clear in the letter or in the code.
And
So I'm not even, when we got the letter and how much time we have, was not the focus of my testimony today. The focus on my testimony is to just point out that which the law director correctly points out that this is not the forum for it, and the time should have been when the law was being drafted, which I was certainly not given any notice of this kind of legislation, or I would have been involved. I would have loved to have sat down with the city and talked it through. And we weren't, and I doubt any owner was. I'm guessing the owners of properties who have to just be caught in this random building size statistic are not happy either, while the neighboring properties, who are our competitors, by the way, who have 9 or more built units, don't have to pay this, don't have to be inspected. Apparently they're not the problem. I just think that it's grossly unfair. I know that's, according to the law director, not something you are allowed to decide about. But I just wanted to come here and put it on the record, because it's just not right. It's not right that you draft a law based on a random number that the EMS people, they're experienced, but I'm sure if you sat them down and said, did you really mean that if a 100-unit property has 8 or fewer units in the buildings and it's professionally managed, that they need to be inspected and they're a problem? I would position that they would say, you know what? No, that's not what we were worried about. We're worried about 8 or fewer units in smaller communities. But anyway, you gotta do what you gotta do, so. I don't really have any-
I'm also curious, the first letter that came out was about the police visit, so I personally came here to the police department and I printed out a year's worth of reports.
but that's not what we're doing.
But I mean, in Mr. Linker, he sent in that we had an appeal, we had a court date, and then it was canceled.
Well, I mean,
And then when a new letter came out, oh, now it's because of 8 units or more. So I just wanted to clarify. But I don't know what happened to the first.
they rescinded it and issued the second. So.
Thank you very much. Mr. Boyer, any closing statements?
Thank you again for your time. I greatly appreciate you hearing out both sides of the arguments. Greatly appreciate you taking your time out Wednesday evening that is absolutely gorgeous outside. We're going to hear us talk back and forth about a code. Ultimately, to reiterate a point that Mr. Linker just made, is that we're not here to talk about whether or not we like the code. It's very clear from the testimony that was presented this evening what both sides' feelings are on the code itself, and any objections to the creation of the code, the timing of the implementation of the code, things of that nature. I would clarify one item from Mr. Linker's statements just now, in that 8 was not a random number, as you heard on the record from Mr. Diorio, that 8 was a number that was presented by several people whose jobs are to keep the city of North Canton safe. And those people came to a determination based on their decades of experience in the city of North Canton that the proper number of units per building that they were concerned about was 8 or fewer. And Mr. Diorio, because his job as Director of Safety Services is to hire people that are competent and credible to take care of this city, he relied on those people in coming up with that determination. But again, here, the board, to reiterate, is not the place to make any sort of challenge, constitutional or otherwise, to the code of issue. The code is the code. That sort of challenge belongs with a different court, a different judicial body, and is beyond consideration of this board. This board is intended and authorized pursuant to the code to review 3 very specific items. Was the code correctly or incorrectly interpreted? Do the provisions of this code apply to the property owner? Are the requirements of this code adequately satisfied by other means? In this case, we've heard testimony and we've gone through the ordinances, and pursuant to Creekside's own admissions, the premises meets the definition as defined in the ordinance. It contains rental units as defined in the ordinance. They're the owner of the property as defined in the ordinance. Those apartments are not occupied by the owner as defined in the ordinance. Each building on their property contains 8 or fewer units based on the statement in their admissions that the buildings contain between 4 and 8 apartments. Going down just line by line, the code is applicable. The code has been interpreted correctly as it pertains to this particular property. The only thing we're left with is whether the requirements of the code are adequately satisfied by other means. And we simply haven't been presented any evidence that it has been, that the requirements of this code for inspections, the requirement of this code to meet all of the requirements of this section have been met by the appealing party by other means. So therefore, the city would respectfully state that Creekside has not met its burden to show that the code has been incorrectly interpreted, does not apply, or has been satisfied by other means. So we would respectfully request that this board deny Creekside's appeal and affirm the decision of the code official in this instance. Thank you.
Thank you, Mr. Boyer.
There,
You already had
out of a bottle, I was wondering on the other means that it's satisfied by other means, which there could be an entire discussion on the advantage of full-time staff inspecting every year. And inspects every apartment. We we are actually accomplishing your goal.
I would respectfully request that the board move on to the decision-making process as the process that's been completed at this point.
You don't want to go down that path.
Again, I would respectfully request that we have given both parties their required time to go through their arguments, go through the rebuttals, and go through the closing statement.
All right, thank you, gentlemen. At this time, the board need to make a motion to, on the violations that are being appealed. Anyone make a motion?
I'll make a motion to deny the appeal by Creekside Apartments.
I'll second.
Thank you. Ben, you want to do a roll call?
Sure.
Motion on the floor is to deny the appeal. Member Coy,
Aye.
Member Pierpont,
Yes.
Member Davis.
Yes.
I'm blanking on your last name. I'm sorry.
Vandergrift.
Vandergrift. Member Vandergrift.
Aye. Thank you.
4 in favor, 0 opposed. Can you say the motion carries?
And the motion carries. Okay, thank you. Is there anything else this time?
Motion to adjourn.
Okay, motion to adjourn.
Second that.
Okay, thank you. We are
Say all
adjourned.
in favor.
All in favor? Adjourned. Thank you.